Welcome back to Breaking U.S. Immigration News. Today's update is extremely important for green card holders, immigrant families, and anyone planning to travel outside the United States in 2026. If you or someone you love holds a green card, is waiting for an immigrant visa, or depends on family-based immigration, you need to listen carefully to this entire update before making any travel or life decisions. What you are about to hear could help you avoid serious problems at the airport, at the border, or even losing your ability to return to the United States. Over the past several months, immigration discussions connected to a possible Trump return to office have raised major concerns across immigrant communities. Many people still remember what happened between 2017 and 2020, when sudden executive orders, travel bans, visa suspensions, and aggressive enforcement policies created chaos and fear. Families were separated overnight. Green card holders were detained at airports. Visa applicants were blocked without warning. Now, as 2026 approaches, similar warning signs are beginning to appear again in policy discussions, campaign statements, and immigration planning documents. Let us be very clear from the start. As of now, no single document officially titled a 2026 visa ban has been signed into law. However, immigration history shows us that major policy changes often happen quickly, sometimes with little advance notice. In previous years, announcements were made late at night, implemented immediately, and enforced before people fully understood what was happening. That is why preparation, caution, and understanding your rights is more important than ever. Green card holders often believe they are completely safe to travel. Many think that once they have lawful permanent resident status, they can leave the United States and return without any issues. Unfortunately, that belief has caused serious trouble for thousands of people in the past. A green card gives you strong rights, but it does not give you absolute protection. U.S. immigration law allows border officers to question, delay, and in some cases deny entry to green card holders under specific circumstances. During previous Trump-era policies, many lawful permanent residents were stopped at airports, secondary inspection areas, and land borders. Some were questioned for hours. Others were pressured to sign forms giving up their green cards. Some were placed into removal proceedings. These actions shocked many people who believed their green card made them untouchable. That is why the phrase travel warning is being used so strongly right now. One of the biggest risks for green card holders in 2026 may come from expanded interpretations of national security, public charge rules, or alleged abandonment of residency. Under U.S. law, a green card holder must maintain the United States as their primary home. Long trips abroad, frequent travel, or living outside the U.S. for extended periods can raise red flags. Even trips shorter than 6 months can become problematic if border officers believe you no longer intend to live permanently in the U.S. If stricter immigration policies return, officers may be instructed to scrutinize green card holders more aggressively. That means more questions about your job, your home, your taxes, your family ties, and your travel history. If you cannot clearly show that your life is centered in the United States, you may face serious trouble when trying to re-enter. The burden of proof falls on you to demonstrate your continued residency intent. Officers have broad discretion, and under heightened enforcement directives, that discretion tends to be exercised more strictly. Another major concern is the possibility of expanded visa bans affecting people from certain countries. In the past, travel bans were justified using broad national security language. Even people who already had visas or approvals were suddenly blocked. While green card holders were eventually exempted in some cases, that exemption did not stop detentions, delays, or confusion at ports of entry. Many people were caught in legal limbo while courts reviewed the policies. If similar bans return in 2026, travelers could face sudden flight cancellations, airport chaos, or being denied boarding before even leaving a foreign country. Airlines often enforce U.S. government rules strictly to avoid penalties. That means you might never even reach a U.S. border officer before being turned away. The experience of being stranded abroad, separated from family, unable to return to your job or home, can be devastating both emotionally and financially. Green card holders with past immigration issues should be especially cautious. This includes people who had previous visa overstays, prior deportation orders that were reopened, criminal arrests, even minor ones, or inconsistencies in past immigration applications. Under aggressive enforcement policies, old issues that were previously ignored can suddenly resurface. What seemed resolved years ago might be reopened during secondary inspection. Officers accessing expanded databases may flag cases that never caused problems before. Another high-risk group includes elderly green card holders who spend long periods abroad due to family obligations, medical treatment, or retirement. Many seniors travel back and forth to care for relatives or manage property overseas. While understandable, these travel patterns can be misinterpreted as abandoning U.S. residency, especially if new policies encourage stricter enforcement. Elderly immigrants often face unique challenges proving strong ties when they no longer work. Their adult children may live independently, and health reasons require extended stays abroad. Public benefits are another area of concern. In the past, changes to public charge rules created fear among immigrants who used Medicaid, housing assistance, or food programs. While green card holders are generally allowed to use certain benefits, future policy changes could again expand scrutiny. Even if benefits used does not directly affect your status, it may increase questioning or delays at the border. Officers might ask detailed questions about government assistance, creating stressful situations even when your benefit use is completely legal. Let us also talk about reentry permits. A reentry permit allows a green card holder to stay outside the U.S. for up to 2 years without automatically being considered to have abandoned residency. Many people think having a reentry permit guarantees safe reentry. That is not entirely true. While a reentry permit is helpful, it does not override all enforcement authority. Officers can still ask questions and review your overall situation. If immigration policies become more aggressive, even reentry permit holders may face delays or questioning. That is why it is essential to understand that no document provides complete immunity from inspection. The reentry permit helps establish that you planned a temporary absence, but it does not prevent officers from examining whether circumstances changed or whether you maintained sufficient U.S. ties during your absence. Another overlooked risk is misinformation. Social media, messaging apps, and unofficial websites often spread panic or false reassurance. Some people claim everything is fine and no changes are coming. Others claim mass deportations and immediate bans are guaranteed. Both extremes are dangerous. The reality is usually more complex. Policies evolve, exceptions exist, and enforcement varies by location and officer. That is why staying informed through reliable sources and preparing ahead of time is critical. Preparation does not mean panic. It means understanding your travel history, keeping documentation organized, and avoiding unnecessary risks during uncertain times. It means knowing the difference between verified official announcements and rumors circulating in community groups. If you are planning international travel in late 2025 or 2026, consider whether the trip is truly essential. If it can be postponed, that may be the safest choice until the policy environment becomes clearer. If travel is necessary, consult with a qualified immigration attorney before leaving. This is especially important if you have any past issues, long absences, or pending applications. Make sure your green card is valid and not close to expiration. Ensure your passport is current. Carry proof of U.S. ties such as tax returns, employment letters, lease agreements, mortgage statements, and evidence of immediate family living in the U.S. These documents can make a critical difference if you are questioned. Organize them in a folder that is easily accessible. Do not pack them in checked luggage. Keep copies both physical and digital in case originals are lost. Specifically, bring at least 2 years of filed tax returns showing U.S. income. Carry a letter from your employer on company letterhead confirming your position, salary, and expected return date. Include utility bills in your name, showing your U.S. address. Bank statements demonstrating ongoing financial activity in the United States can also be helpful. If you own property, bring mortgage statements or property tax documents. If you rent, bring a signed lease agreement. Photographs of your home, family gatherings, and daily life in the U.S. may seem excessive, but they provide tangible proof of your life here. Documentation should tell a clear story. Officers want to see that your entire life is genuinely based in the United States. Your job, your home, your finances, your family, your medical care, your community connections. The more evidence you have across different areas of your life, the stronger your case for continued residency. Think of it as building a portfolio that demonstrates beyond doubt that the United States is your permanent home and any travel abroad is temporary. For those waiting for immigrant visas or family sponsorships, potential visa bans could cause processing delays or suspensions. In previous years, many approved cases were frozen for months or years. Even if your petition is approved, final issuance can be blocked by executive action. That uncertainty can be emotionally and financially devastating for families. Imagine waiting years for approval, only to have the final step blocked indefinitely at the last moment. If you are sponsoring relatives, prepare them emotionally for delays. Avoid selling property, quitting jobs, or making irreversible plans until visas are physically issued and travel is completed. Many families learned this lesson the hard way during past suspensions. The financial losses from selling homes prematurely, the career setbacks from leaving jobs too early, and the emotional toll of extended separation can be avoided with careful timing and realistic expectations. Understanding the visa processing timeline is crucial. There are multiple stages where delays or blocks can occur: the petition approval, the National Visa Center processing, the consular interview, the administrative processing, and the final visa issuance. A policy change can freeze any of these stages. Even if you receive a visa, traveling and entering the United States should happen as quickly as possible, because policies can change between visa issuance and actual travel. It is also important to understand that immigration policy does not operate in isolation. Economic conditions, global conflicts, and domestic politics all influence enforcement priorities. Campaign rhetoric often becomes policy reality faster than expected. What is said during rallies can turn into executive orders within days of an inauguration. That is why 2026 is being watched so closely by immigration experts. It is not about fear-mongering. It is about pattern recognition. We have seen this before. Sudden changes, limited warnings, and real consequences for people who assumed stability. The patterns from 2017 are familiar to those who lived through them, and those patterns are appearing again in current discussions. At Breaking U.S. Immigration News, our goal is not to scare you, but to prepare you. Knowledge reduces risk. Planning reduces panic. Listening to updates like this helps you make informed decisions instead of reactive ones. When you understand potential risks, you can weigh them against your personal circumstances and make choices that protect your family. If you are a green card holder who has lived in the U.S. for many years, paid taxes, raised children, and built a life, your status is strong. But strength does not mean invincibility. The safest approach in uncertain times is caution combined with information. Even long-term residents with deep roots should remain aware that policies can shift and enforcement priorities can change. For green card holders who are eligible for naturalization, now may be the time to seriously consider applying for U.S. citizenship. Once you become a citizen, you gain protections that green card holders do not have. Citizens cannot be denied entry to the United States. Citizens cannot have their status questioned or revoked at the border. Citizens have the absolute right to return home. If you have held your green card for 5 years, or 3 years if married to a U.S. citizen, and you meet all other requirements, citizenship provides the ultimate protection against policy changes. The naturalization process takes time, often 6 months to over a year, depending on your location. That means, if you are thinking about it, you should act soon rather than waiting until a crisis develops. Processing times can also increase dramatically if there are policy changes or resource shifts within immigration agencies. Starting the process now while conditions are relatively stable makes more sense than waiting and potentially facing longer delays or complications. Citizenship also provides benefits beyond immigration security. Citizens can vote and participate fully in democracy. Citizens can sponsor family members in categories not available to green card holders. Citizens can apply for federal jobs. Citizens can travel on a U.S. passport, which provides assistance and protection abroad. Citizens cannot be deported regardless of policy changes. For all these reasons, naturalization represents the ultimate form of security and belonging. As we move closer to 2026, we will continue monitoring official announcements, policy proposals, court challenges, and enforcement guidance. Immigration law can change quickly, but understanding the direction of change gives you power. The more you know, the better decisions you can make for yourself and your loved ones. Before you travel, ask yourself key questions. How long will I be gone? How often do I travel? Where is my primary home? Do I have unresolved immigration issues? Am I prepared to answer questions clearly and calmly? If you cannot answer these confidently, pause and seek advice. A brief consultation with an immigration attorney might save you from serious problems at the border. For seniors, talk to your family before making extended trips. For working immigrants, coordinate travel with your employer and ensure you have documentation of your employment and expected return. For families with children, consider the impact of sudden delays or denials on school, medical care, and stability. Immigration decisions affect entire households, not just individuals. If you do travel and find yourself in secondary inspection or facing difficult questions, remember your rights. You have the right to remain silent beyond providing basic identification information. You have the right to request to speak with an attorney, though one may not be immediately provided at the border. You should never sign documents you do not fully understand. If officers ask you to sign a form abandoning your green card, you do not have to sign it. You can request time to consult with a lawyer. However, asserting your rights may result in longer detention and more scrutiny. This is the difficult reality of border enforcement. While you legally have rights, exercising them can sometimes make your situation more complicated in the short term. That is why having an attorney's contact information with you when you travel is so important. If you are taken to secondary inspection, ask to make a phone call to your attorney. Make sure your family members in the United States know your travel plans. Give them your flight information, itinerary, and expected arrival times. If you do not contact them as expected, they should know to reach out to your attorney. Having someone on the outside who knows you should have arrived and can advocate for you is an important safety net. Create a communication plan before you leave. Designate a family member or trusted friend as your emergency contact. Give them copies of your important immigration documents. Provide them with your attorney's contact information. Tell them exactly when you are supposed to land and when you will contact them. If they do not hear from you within a reasonable time after your scheduled arrival, they should start making calls. Different ports of entry have different reputations for how strictly they enforce immigration rules. Some airports are known for more intensive screening of returning residents. While you cannot always control which port you enter through, being aware of your entry point and being extra prepared with documentation can help. Major international airports like JFK, LAX, and Miami tend to have more experienced officers, but also higher volumes and sometimes more intense scrutiny. It is also worth noting that enforcement priorities can vary significantly depending on the political climate at any given moment. What is routine screening one month might become aggressive questioning the next month if new directives are issued. This unpredictability is exactly why caution is warranted during periods of potential policy transition. For immigrants who work in sensitive fields or hold security clearances, additional considerations apply. Any immigration issues or border problems could affect your employment, your clearance status, or your professional reputation. If your job requires reliability and trustworthiness determinations, Even being detained at the border without any final negative outcome could raise questions with your employer or security office. Students who are green card holders but studying abroad should be particularly careful. Extended educational programs overseas can raise questions about residency intent. If you are pursuing a degree abroad, make sure you maintain clear ties to the United States and return regularly. Consider whether completing your education in the U.S., even if more expensive, might be safer for your immigration status during uncertain times. Business owners who are green card holders and who travel frequently for their companies face unique challenges. International business travel is legitimate and understandable, but patterns of spending more time abroad than in the U.S. can become problematic. Keep detailed records of your business activities, the U.S.-based nature of your company, your employees in the U.S., and the business necessity of your travel. Having a letter from your corporate attorney or accountant explaining your travel patterns can be helpful. Medical professionals, especially those who do international humanitarian work or practice in underserved areas abroad, should document the temporary nature of their work and their ongoing professional ties to the United States. Keep evidence of your U.S. medical license, hospital privileges, professional memberships, and continuing education activities in the United States. Parents of U.S. citizen children should carry their children's birth certificates showing U.S. birth. This evidence of immediate family ties can be compelling. If your children are enrolled in U.S. schools, bring school enrollment documents. If they are involved in activities like sports teams or music lessons, evidence of these ongoing commitments shows your family life is rooted here. Religious leaders and community activists who travel for conferences, training, or humanitarian missions should maintain clear records of their U.S.-based organizations, congregations, or communities. Letters from organizational leadership confirming your role and the temporary nature of your travel can support your case for maintaining U.S. residency. Finally, remember that you are not alone. Millions of immigrants share these concerns. Communities, advocacy groups, and legal professionals are watching closely. Staying connected and informed is your best defense. When policies change, information spreads through networks of people helping each other. Being part of informed communities means you will hear about changes quickly and can respond appropriately. Organizations like the American Immigration Lawyers Association, immigrant rights groups, and community legal clinics often provide rapid response information when policies change. Following reputable sources on social media or signing up for email alerts from trusted organizations can help you stay current without falling victim to misinformation. Consider joining local immigrant support groups or community organizations. These groups often share real-time experiences and can alert you to changing conditions at specific airports or borders. They also provide emotional support during uncertain times and can connect you with legal resources if needed. Thank you for trusting breaking U.S. immigration news. If this information helps you, share it with your family and friends who may be planning travel. Stay alert, stay informed, and most importantly, protect your future by making careful decisions during uncertain times. Remember that being cautious is not the same as being afraid. It is being smart, prepared, and protective of the life you have built in the United States. Your vigilance today can prevent heartbreak tomorrow. We will continue bringing you updates as the situation develops, and we encourage you to check back regularly for the latest information that could affect you and your loved ones.